Good afternoon. My name is Muhammad Abduroaf, and those who are joining us via Zoom, thank you for joining us. And whoever comes and join us, I will just add the details. I think we set. So today's topic is child custody disputes and battles, part 2. How do I get the best out of my case? So if you are watching this video via Zoom, it is for half an hour. If you have any specific questions, you're welcome to type it in and I'll be able to see it. Somebody said hello. Thank you for that. Hello back. If you have any specific questions regarding child custody, please type it in and I'll be able to see it and we can deal with that. If you are watching this video via Facebook Live, that's a link on top, facebook.com/Adv Muhammad Abduroaf /live. You are welcome to post any questions. I'll be monitoring that specific web platform as well. There aren't any questions yet. So let's move on. Let's deal with this topic. Previously, we dealt with this topic regarding child custody difficulties. And as we go along, we'll try to unpack certain issues. The idea behind these webinars are basically to get you to understand from a layperson's point of view how to deal with these specific problems. Many people, they look up the law, they look up the Children's Act, the Constitution, etc. And it's quite complicated pieces of documentation. Me, for one, I continuously have to look at the Children's Act, look at various sections, and sometimes I get confused because those specific sections don't make any sense to me. And then you go to court and you argue a matter, and then the judge has a certain interpretation regarding a section of the law. The advocate on the other side or the attorney on the other side will also have a certain interpretation on the law. But at the end of the day is we like to be pragmatical and sensible and simplify matters. So how do you start this topic? How do you deal with this issue? And I think the simplest way to deal with this issue is when a couple has problems. You can either be a married couple, husband and wife. You could be a couple that was in a relationship, boyfriend, girlfriend, fiance, fiancée, and so on, or somebody that just met somebody and you were in a romantic relationship and a baby came about, and that's where we are. How do you deal with this problem? So the typical case would be a client who would contact us and they'll say, I would like to make a consultation regarding custody rights, guardianship rights, care and contact, as the case may be. So we'll meet with the client. Obviously, the client has no idea as to how the law works, how the courts deal with these type of matters, and how do you unpack and how do you specifically deal with these type of issues. It's the first time that you are dealing with it. You may be a professional person, you may be extremely good at what you do. However, when it comes to these personal issues, you have no idea and you need somebody to assist and advise you. So the first question I would generally ask a person is, what do you want? And believe me, sometimes it takes me a lot of time, sometimes 5 to 10 or 15 minutes to actually find out what this person wants. Then I have to put words in this person's mouth and ask the person, do you want to have custody? Do you want to have the child to stay in your care for the whole week and for the other party to see the child maybe for an hour or two? Then we're getting somewhere and say, no, I don't want that. I want this. Okay. So we go in circles. But at the end of the day, now I can unpack it what this client actually wants. And many times what the client actually wants is just to have peace in his or her life, knowing that as the week can progress, as the days can progress, there won't be any type of issues and controversy happening. So once a person knows exactly what you want, then you can go forward with a specific matter. If what you want is to make the other person's life miserable, if you want is to make the other person to how can I explain to you, to punish the other party, yes, or teach the other party a lesson for not marrying you or not staying in this relationship, I cannot assist you, the law can't assist you, no one can assist you regarding that. But if you know what you want, so if you're a father that you come to my office and you'll tell me, I would like to have structured visitation rights to my child. I separated from the mother a few weeks ago. She doesn't want me to see the child. I can only see the child based upon her terms and conditions. While we were married, there was no issues regarding my family. The child used to visit my family every single day. They used to play with him. We used to go out a lot and so on. All of a sudden, now that I am separated from the mother, she's living with her parents again. My family is not good enough. She doesn't want to have, she wants nothing to do with my family, and she believes my family is bad. And therefore, I can only have supervised contact with my child, who I saw for the last 10 years. I can only have supervised contact with my child at her home, at her parents' home, for a period of maybe half an hour every second day. So things become complicated now, because while the parties were together, life was good. Things were fine. The mother would leave the child alone with the father overnight if she had to go away for work, as the case may be. But now that they are separated, problems happens. So these are the complicated matters that we have to deal with. If the parties cannot resolve these issues, they would want to fight and, teach the other party a lesson and make the other party's life miserable, and they're willing to spend a lot of money in doing that. That is fine and well, they're welcome to do that. But at the end of the day, is after that exercise has happened, they will basically get whatever they are, whatever they are entitled to get, or would have gotten in the first place. So the first question, as I mentioned earlier on, what do you want? If you know what you want, we can take this matter further. So now the parties will come to my office and I'll ask the question, what do you want? And they'll say, I would like to have structured visitation rights to my child, or I would like the other party to have some type of structured visitation rights to the child, or I would like the other party not to have any contact rights or any visitation rights to the child. So that's a basis where you're working from, and life becomes very easy for me. Then I'll ask him the question, how involved was the child in the how involved was the parent in the child's life? That's a very important question, and that plays a big role in taking the matter forward. If the other party was not very much involved in the child's life, then it will affect what type of contact rights he or she will have going forward, obviously. So if someone only saw the child once a month, and now he comes to my office and he was always fine with having to see the child once a month, the question is, can he now come to my office and say, I would like to see my child now every single day? It's possible, don't get me wrong, but if you only saw the child once a month for the last 10 years of the child's life, and that's how the child believes how you are involved in the child's life, and the child continues with his life for the next 29 days, knowing that I'll only see my mom or my dad, a month later. Now you come into my office and I would like to say, I would like to see my child every single day or every second weekend, or I'd like to have midweek contact, as the case may be. We can assist you, but we need to be pragmatical and logical over here. If you want to have contact with a child, it doesn't mean it's there for the taking, for the asking. We need to determine whether or not that is firstly in the child's best interest. Is it workable? If the child lives in Hermanus and you live in Cape Town, and that arrangement for seeing the child once a month was workable because of that, but now you want to change it to every second day, where the child might have to travel now to you in Cape Town, and that will possibly not work. So we need to be logical and we have to be pragmatical. So we need to sit down with a pen and paper. And this is what I advise many people to do. If you're watching this video and you have certain problems, and you and the other party are maybe on talkable terms, as the case may be, sit down with a pen and paper, work out what is a pragmatical and the most logical way of dealing with your child custody problem. If you can get past that hurdle, then your results ultimately will be much more easier to obtain. So let's deal with a scenario regarding with a child living in Cape Town and the other parent living 2-hour drive away from where the child resides, and now this parent wants to see the child every second day. Pragmatically speaking, it won't work. So how do we resolve that issue? We need to get this client. The client wants to see the child more often. He wants to be more involved in the child's life. He feels that for the last 10 years he was limited with care and contact. We need to determine what is the other party's view on the matter. So I'll ask him or her, what does the other parent say about this? Have you discussed this with the other parent? If he or she tells me, no, I did not discuss it, then I'll say that is the next thing you must do. Before you even come to a lawyer, you need to discuss this with the other parent. If you have discussed it with the other parent and you guys cannot come to any type of solution or agreement where the parent caring for the child believes that nothing will work, you're only entitled to see the child 12 days per year, which is too little, once per month, one day per month. If that other parent believes that is best for the child, clearly you're at loggerheads. It could possibly be best for the child, but maybe not. Under those specific circumstances, I would advise a client, firstly, please see a third-party mediator. Let's not send legal letters out here. Let's not, be, how can I say, like trigger happy, be caught happier. I'll give them a number of a social worker or a mediator, as the case may be, and let that mediator or social worker sit down on the table with both you and try to come to some type of a solution. I met with a client yesterday and he asked me the question, we discussed the matter, and then I suggested this mediation process to him. He didn't understand it initially, but now he agreed to it. And I said, the reason why I'm referring to mediation is because you might have something on your mind and she might have something on her mind. But at the end of the day is nobody really listens or hears what the other party has to say. And it becomes a waste of energy because the moment you see each other, the idea is basically to talk and give words over, and the other party's mission is also not to listen to you, and he or she wants to give his words and opinion over, and nothing happens at the end of the day. It's just argumentative. So if you go to a professional, an expert dealing with these type of matters, someone that saw this thing so many times, he or she will be in a very good position to mediate the issue and let the parties come to some type of agreement on the specific topic. If that works, wonderful. You enter into a parenting plan, you come to an agreement, simple. Then you go back to the lawyer, you make the agreement and order of court. If it's a parenting plan, also you can make it register with the office of the family advocate and so on. And that will basically resolve that issue. If the parties cannot come to an agreement after they have met with a mediator, or one of the parties refuse to go to a mediator, which often happens, it's not something which I don't hear of. But if one party doesn't want to go to mediator or mediation failed, then unfortunately the lawyers will have to get on board. Then the parties will have to, the party that came to a lawyer will have to work out a parenting plan, a proposal. How does he believe that the matter can be resolved? What would be best for the child? Is best for the child going a total 360 where the child is currently residing with the mother and now the father believes he must have primary care with the child, where the mother will see the child 1 day per month, for example? Or is a better solution being maybe every weekend for the father to drive all the way down to Hermanus, or the 2-hour drive to see the child? Or is it better for the child to come down to Cape Town if one parent lives down in Cape Town and have contact with the child? Is that a workable solution? If the situation is much less complicated, where the parties live 5-minute drive away from each other, and the father only sees the child maybe every second weekend, but he believes now that the child is maybe 13 years old, 14 years old, he needs to spend more time with the child, and the mother is not willing to do that, or the other party is not willing to do that, then I would say that is a time whereby you write a letter, you attach a draft parenting plan, unpacking the whole situation as to what you believe is a workable situation in resolving this matter. I got a question over here on the Zoom chat. It says the following: if you are no longer together, can you make the other party spend time with the child? History is they never see the child. That's a very difficult question, and I will get back to that after I've explained this issue concerning taking the matter to court. Thank you for that. And if anybody else has any further Zoom questions or Facebook Live questions, you are welcome to post them. Okay, so we're dealing with the situation now. They can't come to an agreement, mediation may be failed, as the case may be. A lawyer drafted a parenting plan, a workable document, and he sent it down to the other party. The other party has an option. He or she can obviously now decide, are they going to be reasonable? And they don't have to be reasonable. I don't force anybody to agree to my parenting plan or to agree to what we have to say. There's always a judge in a court of law that can override my decision or my view, or the other party's view. That's always the case. So you do not have to agree with what we have to say, but you are welcome to give a counter offer. So if my client feels that he wants to have, see the child maybe now every second weekend, and have maybe midweek contact because of the age of the child, and the child wants it, and he feels that he can, provide a better, more quality to the child's life by seeing the child more often, and which could be the case, and the other party obviously refuses that, and that is stipulated in the draft parenting plan, the other party will not be wise if he or she just dismisses that parenting plan. The other party would be smart to look at the parenting plan drafted by his or her lawyer, and to either come with a counter parenting plan, number one, or come with some amendments stipulating, you want to deal with weekend contact. We did discuss this previously. He did bring it up, But I feel that weekend contact will not work because of X, Y, and Z. Wonderful. That's something we can work toward. We can work with. Now at least I know what the other party's view is. She believes that midweek contact will not work because of the child's schooling, extramural activities, the age of the child. The child might have other siblings. You might not want to break the siblings apart. So, for example, if there are stepbrothers, stepsisters involved as well, that's something which the other party can mention and something for us to deal with and to consider with before we jump the gun and say you are being unreasonable. And there might be other issues as well that has to be looked at and which the other party will bring to the table. We will obviously from there onwards, try to maybe chat to the other party and say, maybe we can sit down on a roundtable meeting. Let's sit down, let's try to resolve this matter, amicably. Let us hear more what you have to say. And let my client also hear more what you have to say. And you can hear what our client also wants to say, which is very important. You will note that my entire approach from the start of this webinar is not court, let's litigate. That's what we do. That's what we make, how we make our living. But this is a family law matter. And the way to resolve these matters are not necessarily via litigation. You can actually break up a family, and I believe if a child must be exposed to social workers, counselors, courts, court-appointed lawyers, and so on, violation of the court order, then the mother goes to the police station or the father goes to the domestic violence court, I don't think that's the way a normal household should generally be. The parties at one point, they were in love with each other. They were, in the parents of the child, they were proud of having the child and live together. So when problems arises, does it automatically mean that they should now litigate these matters and third parties should now continuously get involved in the matter? They know the child better than anybody else. And I mentioned in a previous webinar also that why would you want to have a judge or a magistrate that looks at your file for 2 hours or for an hour, or if it's a judge that has a lot of files in front of him and he reads very fast, maybe for 20 minutes. Look at your entire case, listen to arguments by the mother and the father, maybe applies maybe 2-3 hours of his time to it, and make a decision regarding the rest of the child's life and your life. Why leave this whole decision of what should happen to your child and your family in the hands of a third party? That's not necessarily the most wisest thing to do. It's the last resort, yes, of course, because we need some type of normality in this world. So a judge will put down his hammer verbally and he will make an order. But why do that? The judge doesn't know you, the judge doesn't know the child, the judge doesn't know anybody. He just sees some paperwork and some words that gets uttered and he makes a decision based upon that. I'm being very simplistic here, but I think you know where I'm going to with this. It's best for you to resolve your issues together with the other party because you know what is best for your child, you know your personal circumstances and so on. So let's move on over here. So if the parties have met, they have a roundtable meeting and they discuss this matter. Yes, the father might disagree fully with the mother might disagree fully with the father, but remember, if people talk, they chat, things changes. That's where the father starts giving away certain things because he now starts believing that the mother is most probably reasonable on that specific point, and the mother starts giving away certain type of rights she might have because the father comes with the logistical and logical answers. And depending upon how old the child is, we can also get what the child's view is. But let's say that doesn't work as well, and if it does work, wonderful. We enter into a parenting plan, we take it to court, and we finalize the matter. But let's say that does not work as well. The mediation didn't work, letters doesn't work, the roundtable didn't work, unfortunately. Then the question is, what is the next step? In my specific view, it would be the next step would unfortunately have to be court. This is now where the parties will have a third party to adjudicate this matter. Now the challenge you have is, if the parties do not want to go for mediation, they don't want to sit together on the same table and so on, the judge will have to make a decision. But let's go further. Let's try to deal with the topic properly. And the topic for today is, if I may quote it, Child Custody Disputes and Battles, Part 2, How Do I Get the Best Out of My Case? If you are watching this video, please share it on Facebook. It will be greatly appreciated. So how do I get the best out of my case? So we dealt with it so far, getting the best out of a case until the date of the roundtable meeting. That failed. Now you need to make an application to court. And I'll deal today with a scenario of making an application in the High Court as opposed to the Children's Court that we can leave for another day. In your application, you have to be very reasonable. You need to explain to the court in your affidavit, why do you now want to have additional contact? Why do you want to have maybe contact in the first place? Why would you like to have shared custody of a child, as the case may be? You basically stipulating whatever you would have told the court under oath should have been in the, should have met with the judge in court. You're now basically stipulating it in an affidavit, in a piece of document. Now, how do you do that? Are you going to spend the entire, let's say, I like telling clients, you got 40 pages. The first 2 pages deal with who is who in the zoo, and then you got the balance of the documentation to make your case. If you were to spend 20 of that pages bad mouthing the other party, saying every possible bad thing you know about the other party, if you already do that, you have full right to do that, then I'm saying you're wasting your money and wasting your time. You should spend the balance of that documentation, that paperwork, explain to the court logically, I would like to have more contact with my child. These are the reasons why I would like to have more contact with my child. Before that, you deal with a bit of background. And so you can logically explain to the court that I'm not being vindictive. I'm not trying to take any of the rights away from any parents, but I've analyzed this matter, and these are the reasons why I believe it is in the child's best interest for me to have contact to the child X, Y, and Z. That needs to be unpacked. The court doesn't want to hear about the problems you had with a mother in the past, if somebody had an affair, if somebody was rude to you, in-laws, and so on. It's interesting to read. I'll be honest with you, I find it very interesting. But at the end of the day, when I go through the documentation of my opposing counsel, my opposing party, and I find out where are we dealing with the crux of this matter. And my life becomes very easy as opposing counsel is because I can basically ignore all that stuff that happened before the marriage, before the breakdown, unless it's specifically pertinent and relevant. We're dealing with stuff like, example, drug abuse, neglect, and so on. But if it's the normal ranting, talking bad about the other party, I can basically ignore it. It's irrelevant. And if you look at the crux of the other party's 20 pages or 40 pages, only 5 or 6 paragraphs are relevant to the case. What does it leave me with? It gives me the opportunity to deal with their 5-6 paragraphs that they dealt with that's relevant to the case, and it gives me additional, let's say, 19 more pages of explaining to the court why my version of this case is more relevant and why I should be successful in my case, whatever the case may be. So, how to get the best out of my case? Firstly, don't waste your time and energy on ranting, on talking bad about the other party. There are countless amounts of consultation I had in my office, and the clients pay a lot of money for that consultation. And generally, those specific clients, in the first 2 hours, of the consultations, the client will always try to bring about or badmouth the other party. I don't know if it's the nature of how people are. At the same time, if I get phone calls, people contact me, for some advice or don't know what our service, etc. We advise them about that, but they can't stop the phone call. They need to continue and speak more badly about the other party. And it exhausts me because I got stuff to do and I know it's going to. So please, if you are dealing with a child custody matter, focus on the facts, focus on what is relevant. I will now deal with a question that we had via the Zoom webinar, and I see there is a question coming in from the Facebook Live. Let me get to that quickly. It says the following: if you are no longer together, can you make the other party spend time with the child? History is they never see the child at all. It's a very difficult question because if a party doesn't want to see, if a parent does not want to spend time with the child, how do you force that parent to love that child? I, for one, have not yet seen any court law, or as the case may be, that forces someone to, have contact with a child, to spend time with the child and to love the child. And that's something very concerning to me. You can force somebody to pay child maintenance, you can force someone to return the child because you're enforcing your rights to have contact with the child. Or you can make an application to court for you to now obviously enforce your rights. But I never saw an application, or I never done an application whereby we asking the court to force the other parent to love the child and to want to spend time with the child, to have contact with the child. And that's very dangerous because what if the other party now spends time with the child and he neglects the child? Or the other party wants nothing to do with the child, and now you force the child to have contact with him or her, and he just is rude to the child, he's cold with the child, or she's cold with the child, as the case may be. And you want to avoid that. So unfortunately, you can't do much about that. You need to take it upon yourself. I'm the primary caregiver of the child. The other party does not want to be involved with the child's life. That party has an obligation, of course, to maintain the child, take him on maintenance, take her on maintenance. But forcing that person to love the child, unfortunately, we can't do that. I think the law must develop and deal with those scenarios. Then we got another question, and the person says, apologies for going off the topic. This is on Facebook Live. What constitutes an unfit parent? Example, leaving two young children alone at home for 30 minutes to drop off a stranger at 4 a.m. in the morning be seen as unfit, especially if the person is not known to the mother or the children. So for argument's sake, there's a stranger in your home and you leave the house at 4 a.m. to drop the child. You know, it's difficult to say, is that unfit parent, and does that automatically mean that the person must have less parental rights and responsibilities over the child? And at the same time, does it mean that the other party should now by default, irrespective of investigating whether or not that parent can look after the child, automatically be the primary caregiver of the child? It's difficult to make that jump. Obviously, it sounds irresponsible. I don't know what the other circumstances are. I cannot say it's an unfit parent. We don't know the circumstances, the reasons for doing that, and were the children being safe, were they being placed in neglect, as the case may be. So, for me, as a legal practitioner, as an advocate, to say yes or no will be irresponsible upon me. But at the same time, I would say a person that could possibly answer such a question would be a social worker. Maybe speak to a social worker, speak to somebody that deals with childcare issues, and they can and give them more information, telling them the children are 5 years old, 2 years old, if that is the case. It's 4 o'clock in the morning, there are strangers around, it's very dangerous, X, Y, and Z, and find out whether or not that person was being reasonable under the circumstances. If the kids are most probably, 17 years old, 16 years old, they're quite old, and the mother had to go quickly out at 4 o'clock in the morning to drop somebody out, and it's a very safe neighborhood, they have WhatsApp, they have phone call, they have phones, and so on. Obviously, the situation will be different. If it's a newborn child, a very young child, and the mothers leave the child to take the child away, they could be looked at differently. So I would say I cannot give my comment yes or no. It's a bit unfair upon me, but at the same time, the person said thank you for my answer. But at the same time, I would advise speak to a social worker, and maybe they can advise you on that specific issue. So I think we dealt now with both issues, both questions. If there are any other questions, we've got about 10 minutes left for this webinar. I'll be happy to answer it on the Facebook Live or on the Zoom webinar questions. So moving on. So you file your application, you stipulate all that's relevant. So you say, I would like to have contact with a child from Monday to Thursday after school. And in your affidavit, you give you reasons why, logically outlaid, beautifully put out. It will make the other party's life very difficult to argue against it. And if they do it, that's great. You need to give the court all the relevant information for the court to work with it. I always tell my clients, you might come to me with your version. I'll put my best foot forward. I will do as best I can to properly outline, do justice to your case in my documentation. I still need to hear what the other party has to say. And the judge will ultimately make a decision. If you've done that, and that specific documentation goes to court, then you are in the best position to get the best possible results out of your case. It's like this. Courts, and I work with a 40-page rule. That's in my personal practice, whereby my affidavits I draft for my clients are generally maximum between 20 pages and 40 pages of data. I think that's also what judges can most probably quickly scan through and make a decision on for child custody matters specifically. Obviously, depends on the case. And then obviously there'll be some annexures attached to it, like birth certificates, letters from schools, from social workers, and so on. If there's abuse, there'll be some pictures applicable, as the case may be. Obviously, some lawyers will draft long, voluminous documentation, and you don't know what's happening over here. It's the same rhyme. There's no logic. There's no structure behind it. So if domestic violence is an issue, you say there's domestic violence. This is the history of the domestic violence. These are the most recent events on domestic violence. You conclude on it. Next issue, non-compliance with maintenance orders. It's not very important regarding child custody matters, but it's something that could be relevant and pertinent. You deal with it. Court made a maintenance order. He does not pay. Let's move on to the next point, and so on. So that's how you outline your specific information. So if you do that, you're in the best position. If you focus on ranting and bad-mouthing the other party, you won't be in a good position. We have another question. Let me get to that quickly. This is on child maintenance, but I will deal with it because a person asked. The court ruled the other party earns double the salary to only financially contribute 40% of the child's needs. How do I dispute that? If a person earns double your salary, the question is, what is that specific person's expenditure as well? So regarding child maintenance, I know it's off the topic, but I think I will deal with it because the person is in our Zoom webinar and there are no other questions. I might earn 10,000 Rand, the other party might earn 10,000 Rand per month, but I have more expenditure because I must buy, shirts, I must buy work stuff because that's part of my attire for work, I must buy a bib, I go to court, as the case may be. So my money the money that I've left, the net income is much less. With the other parent, he or she might earn the same amount of money as me, however, has less expenses. He works for a boss, pays for all the expenditure at work, gets a clothing allowance, and as the case may be. So his or her net income will obviously be much more to use. So that's what we look at. We don't necessarily look at the gross income. We look at the net income. So it's possible that a party can earn much more than you, but pay the same amount of maintenance as you, or earn the same amount of salary as you earn, but pay less maintenance because of the amount of expenditure that specific person has in order to maintain him or herself. Or for example, if a parent has a medical condition and needs to spend a lot of money on medication, that specific parent obviously at the same time can say, I earn the same amount of money like the other parent, but I have a lot of expenditure, my medical condition, and so on. Or I have to drive further to work, as the case may be. So it is possible. We had a question also on one of our registrants when they registered for this webinar. I said, yeah, I think that is exactly the same question. So sorry, my apologies for not answering it early on, that specific person. So concluding on this topic, how do I deal with my matter? My advice to anybody is watching this video, be pragmatical, be logical, step back from the situation. Don't deal with these type of matters from an emotive point of view. Yes, of course, it's extremely emotional. I mean, I have people coming to my office crying, on the phone crying, because it's emotional, it's their children. That is a factual thing. But we want to be successful in our case. So in order for us to be successful in our case, we need to be logical and pragmatical. There's no other way. I can't see any other way of doing that. Thank you very much for watching this webinar. There are no questions, further Zoom questions. There are no further Facebook Live questions. And we hope to see you at our next webinar dealing with this topic. It will be Child Custody Disputes and Battles Part 2. How do I get the best? Sorry, it will be Part 3. How do I get the best out of my case? Thank you very much.